Now, last year, the Gauteng High Court in Pretoria declared the Sexual Offences and Related Matters Act inconsistent with the Constitution and, invalid. The Embrace Project argues that the provisions of the Act fail to criminalize an accused person's wrongly held belief that the complainant consented to a sexual act. Newzroom Afrika's Zoleka Qodashe is in studio to break down the application before the Apex Court. A very good afternoon to you, Zoleka. An important case in the fight against gender-based violence.
That's correct, Vuyo, and the application tomorrow will be a landmark one and will set a precedent in terms of the Apex Court with any other rape and consent-related matter. So tomorrow, the Constitutional Court is essentially hearing an application for a confirmation of constitutional invalidity of the Gauteng High Court in Pretoria. You'll remember that in terms of the Constitution, when a court has declared a statute invalid, it must go to the Constitutional Court for confirmation for it to have legal effect. So the order of the Gauteng High Court in Pretoria last year in September essentially ordered that the sections, the various provisions of the Act are unconstitutional and invalid insofar as they allow an accused person to evade accountability by having the subjective belief that another person or the complainant in a matter consented to the sexual act. And so that is what the application before the Constitutional Court is going to be dealing with tomorrow. But I think another thing that was important from the order of the Gauteng High Court in Pretoria was that suspension order that was suspended for a period of 18 months to allow Parliament to remedy the defects. But another important thing, and this is something that the applicants will be arguing for tomorrow, is that should Parliament fail to remedy the defects, then the reading in that has been provided by the Gauteng High Court in Pretoria becomes final. Now, a reading in a statute is an addition that a court makes to make the statute or piece of legislation lawful or in line with the Constitution, while Parliament remedies the defects, the unconstitutionality of the statute. And so if Parliament then fails to remedy the defects, the applicants are asking for that reading in to be final, essentially.
It's going to be, an interesting one again, but there are other aspects, I believe, of this law that also need to be remedied.
That's correct. So when the Apex Court hears the application tomorrow, it's going to hear the application for confirmation, but it's also going to hear an application for leave to appeal by the Centre for Applied Legal Studies, CALS, in relation to this application. So they were a party in the application before the High Court last year, and the High Court essentially dismissed their application because of the separation of powers doctrine. What CALS had requested the court to do is to strike the issue of consent from Section 3 of the Sexual Offences and Related Matters Act. And so what that section says is that an accused person or a person who intentionally, because remember, in criminal matters, intent is a very important aspect of it. So intentionally and unlawfully seeks to penetrate another person shall be guilty, or without their consent, shall be guilty of a criminal offence. Now, what CALS is saying that consent in that aspect shouldn't be a factor in the definitional elements of what rape is, and instead should be limited to intentionality as well as unlawfulness, and not broaden the scope to include consent. And so the High Court had argued or ruled that this would be a breach of the separation of powers doctrine because South Africa, in terms of policy, looks at a consent-based model in terms of in rape matters, whereas other nations, in terms of international law, look at a coercion-based model. And so if that needs to be remedied, it would have to go through Parliament. And so because it is a policy of the executive, which goes into executive action. And so if CALS needs such remedy, it would have to go through the legislature and not through the courts. And so the court was mindful of that separation of powers doctrine and dismissed its application. So tomorrow, CALS will also be appealing that order of the Gauteng High Court in Pretoria.
Zoleka Qodashe, who will, of course, be covering that story for us tomorrow, so do look out for her updates.